Everyone. Welcome to this session on governing law after Brexit. My name is Brandon Malone. I'm a barrister with Quadrant Chambers and an arbitrator with Arbitration International. I'm also an adjudicator on the panel of UK adjudicators and various other ANBs, including the CIC, CIR, and RICS. So we have a fantastic panel, although slightly diminished, I've just learned, this afternoon to consider this issue. And their biographies, the full biographies are in the papers, but I'm going to give a brief introduction for each of them, and I'll do that at the outset because we're going to have this session in the form of a discussion. So we have James Bridgemen, SC, Senior Counsel, is a dual qualified barrister, chartered arbitrator, accredited mediator, and statutory adjudicator, with a practice based at the Law Library in Dublin, in the Republic of Ireland, and is a member of Chambers at 45 Gray's Inn Square, London. He's been in general civil and commercial practice since 1992 and took silk in 2017. He has a special interest in commercial and technology law, including intellectual property, internet and construction law, European law and international law, international arbitration, ADR, and other forms of dispute resolution. And he served as the world president of the Chartered Institute of Arbitrators in 2018. And to this Brexit discussion, James is bringing the perspective of someone who is practicing in one common law jurisdiction within the EU, i.e. Ireland, and one which has, of course, now Brexited. So valuable insight from James. Our next panel is our host, panel member, Sean Gibbs of Hanscomb Intercontinental. Sean has held directorships and senior commercial positions with contracting and consultancy firms in the UK and internationally, with over 30 years of experience in the onshore and offshore construction and engineering industries across the globe. Sean has worked across the continents of Europe, Asia, Middle East, Africa, and the Americas. In particular, he has extensive project and dispute resolution experience in the GCC region, working on D&B and EPC contracts in Kuwait, UAE, Qatar, Saudi Arabia, and Oman. He's an expert witness, an adjudicator, and an arbitrator. And I believe you also have a couple of law degrees in your barrister shop. So we are very well served with Sean on this panel. Unfortunately, Georgiana can't join us, but we do have Patrick Waterhouse. Patrick is a construction adjudicator, accredited mediator, expert witness, and contract consultant. He advises clients, contractors, and consultants on all aspects of contract, including contract documentation, certification, claims and dispute resolution, and he specializes in NEC, JCT, and PFI contracts. He's a training consultant and delivers courses on construction law subjects, and he's based in the UK. So a great panel. And we're going to look at the impact of Brexit on various forms of dispute resolution. Has it affected the choice of governing law and construction contracts? In arbitration agreements, how has it impacted adjudication and other forms of dispute resolution? So when we talk about the impact of Brexit on governing law, I think there are two principal ways in which Brexit could have an effect. In the first place, there's the technical effect from the changes in the legal regime that applies to enforcement of mutual recognition of judgments, etc. Secondly, there's the more difficult to quantify issue of whether Brexit has changed attitudes towards using the UK, specifically London, as a place to resolve international disputes and therefore governing law or arbitral agreement governing law. So first we can look perhaps at the technical issues that come out of Brexit, the actual law change. The UK has come out of the Brussels recast regime as a result of Brexit. The EU doesn't seem to be amenable to the UK joining the Lugano Convention, and that means we have the Hague Convention that we're stuck with. So that has an impact on the enforcement of decrease in court judgments, and therefore by extension on the enforcement of adjudication decisions, expert determinations, and certainly in the meantime, mediation agreements, which are all enforced through court processes. Arbitration, of course, has a different regime under the New York Convention, which has not been affected by Brexit. And in due course, we may get the Singapore Convention helping out with mediation, but that's not widely adopted yet. So against that background, what are the legal implications of Brexit for dispute resolution generally, perhaps. And who'd like to start off with that one? Jim, do you want to give us your view on the broad picture?
Yes, thank you very much. Firstly, I'd like to thank Sean Gibbs for inviting me here. It's a great honour, and congratulate you on this huge attendance in the middle of August. You know, that's magic in itself. And I'd like to commiserate you genuinely. Now, I know you think I'm joking, Brandon, but I would really like to commiserate you with all the work that you've been putting into the ICA, and that has been put back and put back and put back. You know, I know how much work you've put into it. And I assure you that even though you might find it hard to believe, that when it comes on, it'll be a great party altogether. It really will, and it will happen. Today, I suppose the three topics are very close to my heart. I chose diversity as the theme for my presidency in the Chartered Institute of Arbitrators. I've lifelong commitment to inclusion and diversity, and I'm delighted to see it back on the agenda. Brexit, I remain an anti-Brexiter, and I pray nightly that it'll be reversed in my lifetime. And then, of course, fees, of course, is something that's very close to my heart as well. But going to your your question, I think in the short term, the big picture is that COVID is likely to have much greater impact on ADR than the Brexit. You've itemized the issues there, and there's no great impact for arbitration, there's no great impact for mediation, and there's no great impact for adjudication. No, that's nuanced, of course. No great, I'm not saying there's no impact. What is probably of more interest to those who are students of the field is that there are two law reform initiatives going on at the moment. One is a law commission consultation. They've reached out to us on the Bar Council of the ADR panel of the Bar Council of England and Wales. They've reached out to us to consult about the future of ADR on the 25th anniversary of the Wolf report, and then secondly, and I think connected with that, probably in the background in the policy in Whitehall, the Ministry of Justice has requested evidence about how from the various stakeholders as to how it's getting on, basically, and so they're two to watch. With arbitration, I suppose the basic point is that the 96 Act remains unchanged for the present, at least. The recognition and enforcement of arbitration awards, it was said in the Brexit debate that it would have no impact because of the New York Convention enforces it. And I think we tend to forget when we talk about Brexit that London is a very, very popular, it's the most popular seat for arbitration. But an awful lot of these international arbitration that come to London aren't in the EU anyway, and so it's business as usual from that point of view. What small things might come from a small, from the big picture, but big if you're involved in, is that the West Tankers decision, as we all know, that predated the Brussels recast, that basically affirmed that you couldn't go and have a torpedo suit in another EU jurisdiction, an anti-suit injunction. That's open now because now the same law that applied to non-EU countries now apply to all countries, or to all countries, including the EU countries. And then I think in the second point that you were making about non-technical legal things, there might be visa difficulties on that for witnesses and so on coming in. Very quickly then about mediation, that's also unaffected. You have the Singapore Convention, which I think probably like mediation itself is a great idea and will remain a great idea to a great extent. There are 53 signatories. There are 6 parties. The UK is not or the EU are not signatories or parties to it. 53, 54 countries. And then with adjudication, that's governed by national law. Both the Irish Adjudication Act and the UK the 96 Act, they both expressly say that the legislation applies notwithstanding a choice of law or another applicable law. So that's come up in a recent Motakis case, which I think may be discussed later on in this discussion. That case was based on the Lugano Convention. Now, the Lugano Convention is quite a discrete little piece of very limited. Doesn't apply to arbitration. It only applies to exclusive jurisdiction clauses. And all in all, I don't see it coming across most of our desks. No, sorry, I'm saying the Lugano Convention. There, what I should be saying is the Hague Convention. I beg your pardon. And as I say, it's quite discreet, and I don't see it coming across most of our desks. The Lugano Convention, I don't think the UK can join it because it's basically done in the context of the single market, and the UK voted with its feet to leave the single market. So I don't think it was ever a runner, really. Sorry if I've spoken for too long.
No, not at all. Thank you very much for that. James, you mentioned the Motakis case there, and that obviously has arisen out of a contract where parties have chosen a different governing law of the contract, substantive law, but also a choice of law forum. Now, I know, Patrick, you've got some knowledge of this case. You maybe just want to talk us through the case and how you see it affecting things.
Yeah, it was an interesting contract which seemed to be designed around keeping as many lawyers in different jurisdictions as possible busy. When the works were in London, it was a refurbishment of a hotel for an Italian employer. The law of the contract was Italian, and the parties agreed to the exclusive jurisdiction of the courts in Paris. That's what the contract said. As James just mentioned, Section 104 of the Housing Grants Act, it says that it applies notwithstanding the law of the contract that the parties have chosen, and therefore it's not something that parties contracting in this way can opt out of at all. And on the face of it, it was a relatively straightforward adjudication enforcement case. Main contractor chasing employer for money. The adjudicator decided something was due, the employer hadn't paid, so off they went to the TCC, and the Hague Convention popped up, as James mentioned. And if I can just read from my notes, because I'm not a specialist on the Hague Convention, but in Article 7 of the Hague Convention on Choice of Court Agreements 2005, it says that interim measures of protection are not governed by the Convention. And as a general principle of adjudication, certainly in Great Britain, it is a temporary remedy. It's designed to get cash moving. And His Honour Judge Hodge QC said that adjudication is an interim measure of protection. It's not final and binding. And therefore, the court did have jurisdiction to enforce this adjudication decision. And I think, as James said earlier, we're unlikely to see too many of these, but it was probably, I think, the first adjudication enforcement case we had post-Brexit that had some type of link to EU jurisdictions, and therefore it did attract quite some attention when the judgment was published.
I mean, which sort of brings me on to this second leg of what we're talking about. I mean, there's clearly a legal implication that's arisen out of Brexit because the old regime didn't apply. We had to look at the Hague Convention, and there was serious and interesting questions around that particular issue. But I suppose the initial thing to observe from that is here is a building project being carried out in England where parties have chosen a different governing law for the substance of the contract and an exclusive jurisdiction clause for Paris. So that there's an example of parties choosing not to use the UK for their dispute resolution or indeed the law of their contract. I wonder, Sean, you're working internationally, we'll have a broad overview of these things. Do you think that's indicative of any sort of trend or movement, or is that just a one-off case? Are you when you're putting contract or you're seeing contracts being put together, is there a discussion around these issues? Is Brexit coming into it at all?
I think there's been a lot of talk about Brexit impacting, but the fundamental reasons people choose a particular governing law hasn't changed. So if I can just touch upon UK adjudication, and I know Patrick dealt with that particular case. I've been doing adjudication since '98, which is about 23 years in the United Kingdom, and I've not seen a choice of governing law clause in any adjudication that wasn't English in 23 years. However, as soon as you leave the shores and you're overseas, and it could be in Africa, Asia, Middle East, you quite often find that people will choose a governing law clause, which isn't necessarily the same governing law as the country they're in. Sure. So we often see, say in Kuwait, the very large oil and gas EPC projects will often choose English law. And despite of Brexit, that hasn't changed. Typically, though, you'll probably have a Korean or Japanese contractor working for one of the national oil companies. So the reasons that they've chosen English law haven't changed because of Brexit. I think where you do see issues or concerns are between European parties that may have considered English law because of Brexit. They weren't sure what was going to happen, and they've looked elsewhere. Now, I think, as we touched upon in the first panel session about diversity, in panels, you've also got diversity in arbitral centres and institutes. And because you've got new arbitral institutes in a whole host of countries around the world, people are looking at other governing laws and also considering will the local courts be able to assist if they choose somewhere else as a seat. Most people are obviously familiar with New York, Paris, London, Singapore, and Hong Kong. And the only country that seems to be growing year on year is Singapore in the amount of cases it's getting. But then you've got to ask yourself, what's the governing law clauses for the cases that are going to Singapore? There's a whole host of governing law there, but quite often people have chosen English law. I see a lot of projects in India where you'll have an Indian company hiring a contractor that could be from anywhere in the world. And they'll choose English governing law, but their preferred seat Singapore. I'm not sure what that was. I don't know if it was my end or whether it's just interference. Sorry about that. So what you are seeing is that there seems to be a preference for common law seats. And common law, governing law in terms of jurisdictions. So I think that's a common pattern. And I don't see that being displaced. I know that Paris has got a commercial court that will handle matters in English now. And Paris still is a popular arbitration seat if the parties speak French. But I don't see that as necessarily linked to Brexit, and I think some of the concerns around Brexit were uncertainty, and we've still got a certain element of uncertainty. I know the application to join the Lugano Convention, my understanding, it hasn't been formally rejected, but it hasn't been accepted. And I think there's further negotiations going on about that. So I think people will be concerned, but it really depends what part of the world they're based in. Europeans, I think, are understandably concerned, but I think people in other parts of the world aren't. And obviously, one of the issues as well in any sort of dispute forum is if you do get a decision in your favour, is how can you collect the money? And probably that's probably of more importance than where the actual seat of the arbitration is, because you can get a decision, but if there's no money, it's worthless, and you're going to stand your own legal costs because you're not going to recover them. And I know in the UK and Ireland, you'll go to court for enforcement, and it gets turned into a judgment of the court, which then in theory can be enforced anywhere in the world. In some of the civil code countries, they're not used to an interim decision that can be enforced. So if you trot off to somewhere else to actually collect your money, you might find they're not willing to enforce the decision, which means that you might be better off using their courts. And hopefully that they might give enforcement to that interim decision. In terms of litigation, and we shouldn't forget that the litigation is still a big, it's still a popular dispute resolution method, not necessarily in construction and engineering, but in other sectors. If you look at the amount of cases that are coming into the UK from overseas, the UK and English law is still a popular seat, and it's a popular choice of governing law. And I think it's really only in arbitration where you've got these alternatives that people are looking around. I know some of the initiatives in Africa to set up international arbitration centres, whilst they might be laudable and will obviously help development of arbitration or understanding of arbitration in those countries, they're never going to be a real contender, a lot of them, for the big international arbitrations. And I think the seats that I've already touched upon, the established seats and the governing laws attached to them will remain popular. And Brexit's just a blip in the progression. I think in another couple of years we'll have forgotten about Brexit and its impacts. We'd have moved on.
Okay, love your optimism, Sean. I think you maybe mean in relation to dispute resolution, or maybe not. But yeah, I mean, you make a good point. Brexit really can only have an effect to the extent, in dispute resolution terms, to the extent we're dealing with European countries, really, because as you say, parties in India, parties in Africa, and other places that are using London, has it really impacted them at all? As James was saying, obviously COVID may be an issue because of the issues of getting witnesses and what have you. But of course, COVID has also, and I don't want to broaden the debate out too much, but COVID has also obviously made things a lot easier in that regard by having virtual hearings, which has become the new normal. But you also, and it's a pity that Georgiana hasn't been able to join us in the event, because of course she would have brought that European civil law perspective to the discussion, and I've been very interested to hear.
Can I just jump in there, Brandon?
Yes.
Georgiana practices in Eastern Europe, and she practices across a lot of the countries there. So she deals with FIDIC contracts where they obviously have dispute boards, arbitration. And I've had various discussions with her about Brexit and its impact on those countries, and she said it hasn't affected us at all. We wouldn't have chosen English law, So some countries, any lawyer, English law doesn't spring to their mind, so Brexit really has had no impact on them.
Okay, so that work wasn't coming here anyway. So that's an interesting perspective. Coming back to the Moticus case, you made the point, Sean, about the attitude of the courts in the EU towards enforcement of interim awards. And now in the Moticus case, neither party gave evidence about what the position would actually have been had the enforcement action been taken in the courts in Paris. I wonder if any of you know or have come across any instance of a court trying to a court in the EU or someone trying to enforce in the EU a UK adjudication award. Is that something any of you have come across or have any thoughts on?
I know somebody had an award, and it was for about 500,000 against a German company, but then they entered insolvency proceedings, so I wasn't able to find out what the outcome would have been. But it was quite a lot of speculation. People, you know, even in the same law firm, different partners had different views of what was going to happen, and they actually had a number of German offices as well. But it's certainly, it must be of concern to people, because I think if you're entering into adjudication, you get a binding award. If you're someone in the UK, you think, oh, I'm just going to get that enforced. It's easy. Well, it's not necessarily easy. So they're going to have to be more careful who they contract with, aren't they? You know, if they're going to have to go off for enforcement somewhere else, they need to give that due consideration. The UK, like most countries, has seen the composition of contractors change. There's a lot more international contractors operating in the UK, both at tier one, but also in the supply chain. And I think parties are really going to have to start thinking about who they're contracting with and what happens if they do have an enforcement of an adjudication, and where they're going to go to get the money in, and if it will be enforced in that country.
I was talking to a German client of mine a couple of years ago, giving some advice on NEC contracts, and they carved out a large part of the meeting for me to explain what this adjudication thing was that was in the contract. And the concept of a temporarily binding decision was one that I still think at the end of the meeting I'd failed to explain, because they said, why would you? If you've got a dispute, surely you want to resolve it and move on. And they were looking at a contract where they were employed under English law, and they were potentially then wanting to engage subcontractors under German law. The project never actually happened. They didn't win, so I don't know. I can't explain how that turned out, but it was a very different view, and it just reflected the fact that we've had 23 years now of adjudication in Great Britain, and we're kind of used to it, where other parts of the world aren't, and therefore will take more convincing.
It isn't. Sorry, can I just jump in there? Sorry, James. I think it is interesting though, because Germany and the arbitration, the DIS body there, have actually got their own adjudication scheme now. I'm not sure if it's been successfully used or if there's been any enforcement. So if anyone's listening that wants to tell us if it's been used and they've got any experience of it, it'd be really interesting to know that. But it does seem that some of the civil code countries now are starting to consider adjudication in different contexts and open to maybe using it.
It seems to me that enforcement is all about where the money is, and at a contractual stage, anyone drafting an agreement or entering into an agreement must be looking at, in construction, they are looking at bonds, they are looking at what will happen at the end of the day if there is default of one sort or another. Now, in ADR, most ADR, and I think it's important for us to always remember this when we're talking about arbitration and ADR, is that most cases are small and most cases are domestic and regional dispute resolution institutes. They will succeed if they have a body of domestic disputes, and that's a prerequisite to success. Looking to make money from international arbitration is designed for failure, basically, in the competition of the ICC, the LCIA, the ICDR, Singapore, and so on. It's a very strong cluttered market there, and it's hard to break in except for maybe low hanging fruit. But the point is that that you come back to the fact that any dispute, even if it is an international dispute, it has a seat. And that seat is where you're going to go to get your order for enforcement in an adjudication context. If you have an Irish adjudication, you're going to go to the Irish court to convert the award into a judgment, and then you go to enforce it. Now, if that's the case, then there's a facility in enforcing an Irish award throughout the EU. And that has been heretofore the situation within the UK as well. But that's unique in the world, because mostly if you have a case involving a German and a UK and an American company about some project in the Middle East, you don't have anything like that. You know, the enforcement is a real problem. And there was mention of a big Nigerian case there earlier on this morning. I mean, that's a saga. Of the enforcement aspect of that is a saga. So I think myself that when we come back down to it, that if you have a judgment of a UK adjudicators award, then, or an Irish adjudicator award, well, you can go, and in the UK case, you can use the Committee of Courts, and you can use the process. It's expensive, it's lengthy, it's difficult, it's fraught, it's complex, and it's uncertain. That's for sure. But it is there, so it's not as if you can never go after money. It's easier. It's an awful lot easier with the Brussels regulation recast, and it's probably somewhere in the middle. You know, with the convention, with the Lugano Convention, because there's only about 4 other small countries within that. So from that point of view, I don't see a major issue for an enforcement of an adjudicator's decision being any different from a judgment in any other judgment going to America, say, for example. Now, you come up with defenses that it's an interim decision and all of that kind of thing. Paper doesn't refuse ink, and that's the case. So it is more complicated, whereas it's very simplified with the Brussels regulation, because you've got an actual judgment of a court. That's it. You've got that. They have to recognize. They have to enforce it. An arbitration award, you go with your award, and you can enforce it. And there's universal acceptance of the New York Convention. So that, but again, that's an award in a foreign country enforced in a domestic court where the money is, and depending on how transparent that world is and that legal system is, and that depends. That depends again on the choice of law and the choice of seat as well, which will certainly impact on that. So it's complicated.
It's quite interesting, James, what you said, and I've noticed a few times when I've been involved in some matters in the Middle East where parties have fallen out and they're saying, "Oh, don't worry, we've got an ICC arbitration in the seats London." I said, "Oh, that's good. You're going to get a decision then." I said, "But you're still going to have to collect, and you're going to have to go back to the country. You've got to go back to the country's court that you didn't trust in the first place to actually collect." So
I remember being at a conference in Dubai, and one thing that I remember from all of the things that were said was,
have we lost James there? Or
I can't hear him.
Oh, sorry, James. I think we've lost your sound somehow.
have you lost my sound? It doesn't look like. Can you?
You're back. I think you're back.
Am I gone? Am I back?
Yeah.
You're back. You're gone again.
I think you got connections.
Yeah, I probably changed. I've changed my I changed my I changed my connection. Can you hear me a bit better now?
Yes.
Okay. So it's just that that I remember it being said at a conference that that even awards against states are eventually satisfied in the Middle East. That came up as an issue, but it takes time, you know. That's the difficulty.
But specifically with regard to adjudication and the issues that the Moticus case highlights, are there dangers there? I mean, obviously the exception is being granted in part. One of the exceptions about it being a matter of public policy was rejected. But are there opportunities for Ireland, for example, if it's going to be easier, if the doubt is going to be removed about enforcing an interim measure, an adjudicator's award?
Well, I think there are opportunities in arbitration in Ireland. I think arbitration is a very different animal from adjudication in that regard. Ireland, a lot of people know, you've been told for a long time by a number of organizations like Arbitration Ireland, that Ireland is a very good seat. It's not a seat that's used, but it has everything in place. It has the Untitled model law. It has a commercial division of the High Court, which is second to none, and improving all the time, you know, with new appointments. And so it's a safe seat, and it has this advantage of being within the EU now. So there isn't, I suppose, probably there is an issue hanging over third-party funding in Ireland. There are two views on that. You know, one view is that a decision on third-party funding, saying that it was basically chapertus, arose in the context of litigation and not arbitration. I'm too conservative of a lawyer to buy that. You know, I think third-party funding is definitely problematic in Ireland. Beyond that, it's a very good seat from that point of view.
Thank you for that advert for Ireland, Gibbs.
Well, no, I didn't mean it that way.
You're absolutely right. But I mean, I think with arbitration, though, in this context, we have the New York Convention, so it is less of an issue. I was really thinking more about you mentioned because an Irish court decree is exportable to the EU. Is there an advantage there? You know, automatically, is there an advantage there? Is there some possible? Is it something parties should be thinking about in adjudication terms for these interim awards? I should also mention, of course, as I'm contractually obliged to do, that Scotland has a very good seat of arbitration as well, which is a hybrid common law, civil law jurisdiction.
That kind of goes without saying.
Although I say it anyway.
The difficulty, as you know, is that the adjudication is, and the Moticus case illustrated, it's something within a jurisdiction, and I can't see how it's likely that you'd get an enforcement of an English or a Northern Ireland even or Scottish decision in the Irish High Court. I haven't thought about it, and
no,
maybe it'll be tried.
I haven't thought about it either. It's just arisen out of the discussion, James. But I mean, I think just thinking it through, in the Moticus case, they specified that the French courts had exclusive jurisdiction. If and as you say, the adjudication regimes are connected to the place where the works are being carried out. But if enforcement or if there was an exclusive jurisdiction clause in the Irish courts, which then permitted you effectively to enforce an adjudicate or obtain a decree conform to the adjudicators award in an Irish court and then export that automatically across the EU. Perhaps that would be advantageous, because obviously Ireland is a jurisdiction that recognises adjudication, has its own regime, and it wouldn't be an alien concept, as it may well have been in the Moticus case, which is perhaps why they didn't try and enforce it in the French courts, notwithstanding the clause.
Yeah, perhaps, and in it, if I'm sure that that's something that could be explored, particularly in construction where you have large engineering projects, or very large building projects, where you have parties coming from very different jurisdictions, and you'll find a lot that there are a lot of pan-European consortia. In the large building projects, so that's possibly, and it's something that commercial lawyers mightn't have too much of a problem getting across the line at that point.
You know what I've seen, and it seems to be quite common on large mega projects where you've got various JVs making up the first tier, and then there's subcontracting, is that some of them will put a great lot of thought into governing law clause for the main contract, and then the supply chain has totally different governing law clauses. I've seen that in Asia, and the problems were, one, that the team that actually administered the contracts didn't understand what the ramifications of the different governing law was, and the biggest issue was that they had the disparity between the limitation periods. So what somebody had done initially, it was good, but they hadn't cascaded it through to the people who actually had to run the projects. They weren't aware that they were going to be time barred. And just as an example, there was English law, Indian law, Japanese, Spanish, and New York. And it was really complicated trying to work out who you needed to go against first, and working out a strategy, because some of the JV partners needed to resolve claims up against the main client. Then they needed to fight the supply chain before they could start fighting amongst themselves.
Well, I think that's one of the things that come through all dispute resolution conferences and looking at agreements and looking at the type of clause that we're presented with. But in supply chain in particular, very often you're dealing with very different supplies coming from locations, with smaller entities, specialists who are uncomfortable moving out of their own world, and are uncomfortable working in another language and giving a hostage to fortune. I mean, when I'm advising small companies, I always put in as a deal breaker, if they're doing an international contract, I always put in that you pick your jurisdiction, whether it's the UK or it's Ireland, that it's arbitration in the English language in the jurisdiction that where my client is based, and that gives me a possibility of helping my client in the event that it runs into a small value claim or a large value claim, and it keeps in international context. Because I've come across in intellectual property, one of the first times I ever came across it was a long time ago. A guy had a very good trademark in the United States. He had paid for the registration. It cost him £500 or something at the time, and but he had no wherewithal whatsoever to enforce it. Because of that. So it's that's one of the uses of arbitration, is for the small person to come and have a home game, basically, in a language that they're familiar with, and that's part of the flexibility of it, Sean, I reckon. But I just think adjudication is a little bit different, because the actual how you categorize the requirement for adjudication. There's a lot written and spoken about. Is it an employed term in a contract, or is it not? Is it something else? Is it a statutory right?
That's the main difference between England and Ireland, isn't it, essentially? And I know that's one of the issues about enforcement in Ireland, in terms of you could do a judicial review and there are a couple of judicial reviews. And I suppose adjudication is gaining popularity around the world. Obviously, common law countries have various statutory schemes which all differ, but there's also countries such as South Africa that don't have statutory adjudication, but they have contractual adjudication, and the courts there have been very willing to enforce decisions, and they've also been particularly guided by the decisions of the TCC court. I know Dyson and Jackson's decisions about cash flow and, you know, rough and ready justice, you pay now and argue later, have all been taken on board. But as we've seen more and more use of FIDIC forms of contract, and obviously it's a different type of adjudication, but nevertheless it is a form of construction adjudication, whether we're going to see a sort of need for maybe a global convention. You know, we've got the Singapore Convention on Mediation. I think there's 150 countries signed up now or more. I'm wondering if we're ever going to get that for adjudication.
Well, the Singapore Convention isn't that popular. That's one of the difficulties, you know, with it, trying to get the countries to come on board. But it's very, I find big differences between different jurisdictions in adjudication. I did a training course in Toronto a couple of years ago when they were introducing it, and it was quite remarkable. It never would have succeeded in jurisdictions that I would be familiar with. They had a certain price for an adjudication depending on the value, and also the price, a limited number of words in the adjudicator's decision, and it was a tiered value, you know, coming through, fixed price. And it just I mean, the rules of natural justice are so embedded in a lot of the case law from the TCC and the Irish case law coming through now, that wouldn't work here, but it probably would work in Toronto, because they've decided to do it that way, you know. And so it's not something that that would be consistent across the world, is my point, you know. From a convention.
I think that would be a very difficult negotiation, trying to get a convention on adjudication, but you never know, I suppose.
I can see that we're running out of time, Brandon.
Yes, so I see the overtime, and it's the time that was allocated for lunch, so that's the worst possible overrun. So I suppose we should draw things to a close.
I was just going to give give Patrick the chance to make a closing comment. I know that James and I have dominated it slightly.
I would just like to make a further comment on Matarkas, because I made a mistake. I realised it wasn't employer main contractor, it was a subcontractor against a subcontractor, and it reminded me of the fact that we've got an eminent lineup of people here, from which I'll exclude myself from that compliment, who frequently advise people on what the choice of law or the seat is and so on. And we forget that a lot of the people we end up dealing with in disputes have not thought about this. Someone put a piece of paper under the nose and said, sign here, and they've done it because all they want to do is build something and get paid. And because none of us starts out in a contract saying, well, we're bound to be in disputes, we best think about this properly. The two participants in Matarkas were a UK fit-out contractor and an Italian furniture and fit-out contractor. And I don't know the details of the case other than what the judgment says, but it's entirely plausible that neither of them really thought about this when they set up the structure that they did. I think that overall adjudication is a force for the good, but you know, I would say that, wouldn't I, earning a living out of it. But I think there is a case for a widening of adjudication standards and procedures. And of course, a pat on the back for Sean, who this week has been appointed by FIDIC to their adjudication panel. And I think the more we can standardise adjudication procedure across the board, the better. But that still comes back to what James has said, which is, you know, where is the money? I don't think we can necessarily standardise how you collect the cash once you get an adjudication decision that meets your desires.